Mr. Murlidhar, thanks for joining me. Thanks for being my guest.
Welcome. I'm happy to be here.
My pleasure. So, Mr. Murlidhar, I just want to start with to set the record straight. The BJP supporters continue to give credit to Mr. Modi for the conviction of Sajjan Kumar. Since you had delivered this historic verdict, to what extent this statement is appropriate or based on facts?
See, political parties will try and take advantage of every development. So this case was pending before the Delhi High Court for many years. And it so happened that it came before my bench and we heard it on a continuous basis and delivered a verdict.
Hmm.
So it may not be correct for any political party to take credit for what actually happens in a court.
Hmm.
So judges have to hear cases on merits and decide and deliver judgments. So this is my answer to your question.
Right. Now, since you have acknowledged that this case has been pending for a very long time, so having delivered such an important verdict, when you look back at the history, how important it is for you?
Not just for me, I think for the country it's important because India has had a history of impunity for mass crimes.
Hmm. Hmm.
You could even trace it back to the harrowing days of the partition. You know, with complete impunity, crimes were happening even in the capital city of Delhi,
Right.
and there was no accountability. Law and order completely broken down. I'm talking of 1947. Then, if you
Absolutely.
take even the post Babri Masjid events, again you saw a whole wave of impunity for mass crimes. 1984 was a real shocker
Hmm.
in every sense of the term because it was happening in the capital city of Delhi. And one could see that the police machinery was completely, hand in glove with the perpetrators of the atrocities. So if somebody wanted a textbook definition of impunity, and I'm not talking immunity, impunity meaning refusal to bring to book
Hmm.
the perpetrators of the crime because the state is actually encouraging these crimes. So you find a pattern repeating through history.
Right.
And I'm talking Indian history, 1947, 1984, but you have many riots situations. 2002 in Gujarat, the Kandamal riots in Orissa, the Muzaffarnagar riots. You'll find many of these instances, either they don't simply register cases against the main perpetrators,
Hmm.
or the trial goes on for so long that witnesses fail to appear, the trial becomes a mockery, and nobody gets convicted. So it could be either of these situations. It's basically a failure of a state to perform its primary function of ensuring safety and security of its citizens. So
Definitely.
this kind of a situation needed to be actually tackled, which is why this judgment is significant because it took as many as 33 years for the first proper conviction of one of the major perpetrators of the crime being brought to book. And even
Definitely.
now, actually, his appeal is pending in the Supreme Court.
Hmm.
And the final word has not yet been said. But, at least he's still in jail for the conviction that he has suffered. And it's only Sajjan Kumar and the 3, 4 others who got convicted.
Hmm.
There are so many others in the 1984 riots who've not been brought to book at all.
Right.
So it is significant because it also records the failure of the system. There are two ways of looking at this judgment. One, of course, it reaffirms the faith, one could say, that however delayed, justice will ultimately be done. But it also records the failure of a system not to bring to justice perpetrators of such a mass crime for more than 3 decades. And this is a failure that's getting repeated over and over again. So the judgment is also a pointer to what are those fault lines in our system, why we need witness protection, you know, and why we need to do something about our law itself. See, the judgment points to two major developments in international human rights law.
Hmm.
We have conventions now which have established the International Criminal Court. We've always had a genocide convention. With the ICC court being set up, the statute, setting up the ICC recognized the crime of crime as crimes against humanity.
Right.
Both these crimes sought to be defined in the wake of the Second World War. Despite India being a signatory, having ratified the Genocide Convention, still has not defined the crime of genocide in its statutory criminal law, domestic criminal law.
Right.
Likewise, India has not defined the offense of crimes against humanity, despite that occurring on a regular basis in many of these riots situations. So this is unfortunate, and the judgment is appointed to that as well. So it is a very significant judgment in many aspects.
Definitely, definitely. Now that brings me to my next question, Mr. Murlidhar, that you also mentioned about the 2002 Gujarat massacre in the verdict itself. You mentioned about it now, but you also mentioned about it in the verdict.
Correct.
So how
Correct.
significant was that considering the complicity of the Modi government back then in the state?
Yes, it is. That's what I'm saying. No, at various points in time, the government, the executive government, is complicit because it does not either prevent the crime from happening, but actually creates a situation to facilitate the commission of the crime.
Hmm, hmm,
So, for instance, sharing information of the vulnerable groups with the perpetrators of the crime,
hmm,
right? Deliberately leaving unguarded those vulnerable areas.
hmm,
And third, of course, is most brazen, standing by quietly watching while the whole thing happens,
hmm,
doing nothing about it. In many of our riot situations, you'll find video clips or photographs where you find a policeman or posse of policemen standing by helplessly just watching as bystanders.
hmm, hmm.
So you 2002 was another classic example where the NHRC had to step in. The National Human Rights Commission had to step in with a petition before the Supreme Court of India, asking for a fair trial, for booking cases, for arresting people, to get the criminal law, criminal justice, mechanism both set in motion and actually work. See how you register a crime, like for instance, the Northeast riots in Delhi.
Right,
If you're selective about which community will get, you know, targeted for registering of affairs and which will get left out,
right.
then the partisan nature of your investigating agency gets exposed.
Hmm, hmm,
So it's not just the 2002. Of course, I mentioned 2002, but I also mentioned, I think, Kandamal. Those things were
yeah,
also mentioned because in many of these situations, you find there's a failure by the state police, the local police force, to actually do anything active to stop, to prevent the crime from happening, although it's getting played out right in front of their eyes.
absolutely, absolutely. No, Justice Murlidhar, what exactly happened during the 2020 Delhi violence that the BJP was so annoyed by you? They tried to transfer you from the
No,
Delhi
actually,
High
yeah,
Court.
I need to set this. Yeah, I need to set this right first. See, my transfer was already under process.
Okay.
That is, there's enough accounts written about how the members of the Supreme Court Collegium, they've themselves written about how there was pressure from the government
Hmm.
to get me out of Delhi. So that these have come in the accounts of the judges who constituted the collegium. It's there in the public domain. So some of the judges resisted it. So these moves were in motion since 2018, 2019.
Hmm.
But at various points in time, some judges of the collegium resisted it.
Hmm.
But when Justice Bobde took over as Chief Justice, his collegium had already recommended my transfer. This
Hmm.
was before the actual riot situation happened.
Hmm.
Now, while that transfer was still, that recommendation for transfer was still pending, notification by the central government, because it goes to the president who then issues the warrant. At that juncture, this whole thing happened, which is the riots in Northeast Delhi, and my holding a midnight hearing on the intervening night of 25th, 26th February, where I had an emergency hearing in my residence to facilitate the movement of injured persons by an ambulance to hospital for medical relief.
Hmm.
Even the ambulances were not being permitted to pass, which is why we needed to hold an emergency hearing at midnight in my residence.
Hmm.
Those orders were passed and lives were saved. next morning, when I sat in court, I was the senior most judge because the Chief Justice of the Delhi High Court was on leave. The second senior most, the immediate senior most judge was not holding court. So I had to necessarily deal with the petitions that were before the court of the Chief Justice, which included public interest litigation cases. And one of those cases asked for police action on the hate speeches that were being circulated on social media. They were all going viral. The speeches of Anurag Thakur, Kapil Mishra, and so on, Parvesh Verma, and so the four BJP leaders' speeches, which were clearly inflammatory, they were circulated in social media, and the petitioners were asking why is the police not taking action. So when I began hearing, this is on the morning of the 26th, and I started asking some questions, which of course the government felt uncomfortable about. First of all, they denied that there were any such clips, which compelled me to actually play out those clips in court. And the police could no longer be in denial that there were these clips. And it was plain for anyone seeing those clips that those speeches were inflammatory. And one test of where the freedom of speech ends is where the speech can incite violence. This is one of the most basic tests.
Absolutely.
And if you again needed a textbook example of speeches leading to violence, it was these speeches. They were actually asking people to go and attack whom they considered to be, gaddars, and that those words were actually used. So that the police was not taking action was a matter of a concern. So I was actually asking for accountability. I basically told the police commissioner, you better come back tomorrow and tell me, what have you done after seeing these clips? This is the simple question I asked him. And that triggered this whole notification. So you've never had a situation so far where a notification transferring a judge is issued at 11:45 in the night. Literally, when the notification reached me, it was midnight. So it is clear what triggered this notification, the timing of it. You see, it's so plain that somebody actually took the file hurriedly up to the president's house. The president has to sign the warrant.
Right.
So something triggered. So after the hearing, by midnight of that very day, the notification was issued. So it was, of course, a midnight transfer. Although they keep saying the transfer was under process, what clearly triggered the notification were these hearings that happened on the intervening night of 25th and 26th and during the morning of the 26th of February 2020.
No, that's very telling. That's very telling.
Let me also add this. I was certainly not surprised because, like I told you, there's been a history of from 2018, 19, somehow finding ways because they sensed that, I'm not going to be swayed by anything at all. I'm going to ask tough questions while sitting as a judge. So that probably, and must give it to the credit of the Supreme Court collegiums of those years, they did not succumb to the pressure. They finally succumbed to that pressure sometime in early 2020. I was not surprised, and I have no regrets. If another question that many people ask me, because not only did I have 9 months of very satisfactory tenure in Punjab, but I had a 2.5 year tenure in Orissa as a Chief Justice,
Right.
where we could bring about some changes in the way that judiciary there functioned, digitization of courts, all of that.
Definitely.
So no regrets as such that they dealt with me this way.
Right. Now, Justice Murlidhar, how do you look at the current state of affairs as far as the Indian judiciary is concerned?
See, they have somewhere lost the initiative in asserting their independence. There have been various moments in the last 11 years where the judiciary should have put its foot down and said, no, we're not allowing you to, interfere with the way we function.
Right.
So whether it's the matter of appointment of judges, transfer of judges, appointments to the Supreme Court, non-compliance with their own orders, the judges have not been tough. They've not been, assertive. They themselves give a judgment. The judgment is not complied with. They're reluctant to pull up the central government. It's happened time and again. I'll give you a few examples. In a non-human rights context, they've been setting up tribunals for various kinds of issues. Now, one of the problems with the tribunals is the members are appointed not through a rigorous process like High Court judges or Supreme Court judges. They're appointed by a selection committee, and their appointments are notified by the central government. Those tribunals work under the administrative control of a ministry of the or a department of the government. So straight away they lose their independence because they're working directly under a ministry. Their facilities, their infrastructure is all provided by that ministry. Second, their tenure of appointment is limited.
Hmm.
So the Supreme Court passed a very detailed judgment saying that tribunals will not perform the work of the High Court if you're not going to give a certain degree of independence to the tribunals themselves. They need security of tenure. So they said you can't have these short tenures. You can have a retirement age, but you can't have a member of a tribunal for 4 years and 5 years. Now, despite the Supreme Court saying this in two judgments within a span of 1 year, the central government refuses to comply with it. It has amended the Finance Act and again provided only for short tenures of 4 years for members of these tribunals. Now, the Supreme Court should have said, we are stopping you from doing this. But the Supreme Court is reluctant to do that. This is one example. Second is the Anuradha Bhasin case. This is a clear human rights situation where Jammu and Kashmir, there have been internet shutdowns for very long periods of time. So all that the petitioners there, and this is impacting directly the freedom of the press in Jammu and Kashmir. So one of the media persons approached the Supreme Court to say, you can't have a blanket shutdown of the internet. You must show some justification, right? What are the reasons why you're having a shutdown? And you can't have a shutdown permanently. You can't have it for months on end. So the Supreme Court agreed with that petitioner and passed what was considered a remarkable judgment, saying freedom of access to the internet, freedom of internet is part of the freedom of speech, and how it's very much part of the freedom of the press. So it's quite a progressive judgment. But that judgment never got implemented because there were specific directions in that judgment about how they needed to first upload all these orders, shutdown orders, along with the reasons why they passed that order, and how they are supposed to review those orders periodically to see is there a justification for continuation of the internet shutdown. The government refused to comply with this. And when the petitioners went back to the Supreme Court to say, listen, your judgment is not getting complied with, the court is reluctant to do anything about that. So, in one sense, therefore, the court says, okay, I may have passed a judgment, but don't ask me to implement it. Now, this shows actually a weakness of the judiciary.
Right.
See, the judiciary should be asserting itself that I'm the final word, and what I say is the law, because there is an article 144 of the Constitution which says the judgment of the Supreme Court is binding on everyone. And 141 says that, this is the law of the land. It has to be obeyed and complied with by everybody. And when you complain of non-compliance and you go back to the Supreme Court and say you're not doing anything about it, the Supreme Court is just keeping quiet. Now, the third instance is Pegasus, right? It's a spyware that the government has actually bought. It has, utilized that spyware and has, used it to place mobile phones of journalists, even Supreme Court judges. One of the Supreme Court judges' mobile phone was placed under surveillance using the Pegasus spyware. In a petition filed, leaders of the opposition and so on and so forth, in a petition filed with the Supreme Court, the court appoints a committee headed by a former judge of the Supreme Court. Right? That committee, in fact, tells the Supreme Court the central government is not cooperating. The committee is, in fact, submitted a report. That report is not being seen by the Supreme Court.
Wow.
The case is not listed for hearing. This is such an important issue. How can, the government itself purchase spyware to place its citizens under surveillance without, consent, without any authority of law? And these are very, very serious issues concerning freedom of the press, general security and safety of citizens, and asking for accountability from the government, right? And if the Supreme Court does not have time to deal with it or is reluctant to even list this case, then we have a serious problem. So all these instances show us that where the Supreme Court should be asserting itself as a guardian of rights, as an institution that should be seeking answerability and accountability of the executive government. Right. It is perhaps not doing that.
Absolutely. Absolutely. Now, one final question for you, Justice Murlidhar. What is the future of judicial activism under the current government?
See, I should tell you on a positive note,
Hmm.
there will always be lawyers and concerned citizens who will keep knocking at the doors of the court.
Right.
And you may have those occasional bright moments when
Hmm.
some judges agree with the concerns of those petitioners and give what I would consider as progressive judgments. So while we would like to say that everything is bad, bleak, and hopeless, every now and then there will be some ray of hope, some good judgment, some good order. Like, just 10 days ago, Justice Gawai's bench, the Chief Justice, present Chief Justice of India, Gawai's bench, gave a judgment where it mandated that not just for the regular criminal law offenses, but even the special laws like the prevention of UAPA, Unauthorized Activities Prevention Act, and for the NDPS Act, those kinds of cases too, a person under arrest has to be informed of the grounds of arrest
Hmm.
in a language that the person arrested understands. So they put on a really high pedestal, and which is there in the Constitution itself, that this is non-compromisable, informing a person of the grounds of arrest.
Hmm.
And they've gone one step further. They said, well, if we find that you have not done it, the arrest will be illegal, of course. But everything done pursuant to the legal arrest will also be illegal. So this is actually a very big step forward. So this coming at a time when everything seems to be a bit, bleak, gives us a ray of hope. Then the last year there was a judgment which said segregating prisoners on the basis of their caste
Hmm.
and allotting them work in prisons depending on which caste they belong to is all unconstitutional. That it happened in the 75th year of the Supreme Court is something that we should heave a sigh of relief that there's a court which actually is calling out these practices as unconstitutional. So while I would generally agree that overall the track record is not as good as it should have been, every now and then there are these persons who knock the doors of the court with the hope that justice will be done. And there are occasions when the court actually answers that
Hmm.
call. It should be more often, definitely. It should happen more assertively, and it should happen more consistently. Today we are having one set of judges react in this particular way to a petition, and a similar petition goes before another set of judges, they react completely differently to it.
Absolutely.
And then you wonder, how can both of these things be the Supreme Court of India? But that's the reality with which we live. And as lawyers and as concerned citizens, I think we must keep that hope alive, and we must expect that we should do our job, whether the court, answers our call every time or not, irrespective. We should keep knocking on their doors for justice, celebrate when justice is done, criticize when justice is not done, keep our freedom of speech intact, and keep fighting for it.
Very well said. Very well said. Justice Murlidhar, thank you so much for your time. Is there anything I didn't ask you before I let you go?
No, no. You mean something that I want to add on my own?
Yeah, if you want to, please take
Yeah.
an
One thing
opportunity.
that concerns me is about the freedom, the independence of the bar,
Right.
the lawyers, right? We find that the lawyers as a body should be more sensitized to violation of human rights
Right.
and curtailing of freedom of speech, particularly when you have an electoral, they call India now an electoral autocracy,
Hmm.
right? Where by sheer numbers, a certain dispensation is in power. And we must be even more vigilant that our rights should be preserved in moments like this. Because history teaches us that majoritarian governments have a tendency to ride roughshod
Right.
over constitutional values and liberties and protections that the Constitution offers. So, as lawyers' bodies, we must be more vigilant. We must be more, out there in the front, asking for protection of freedom of speech, asking for protection of the interests of minorities, because ours is not a dominant majority democracy.
Right.
That's a very simplistic definition of democracy.
Absolutely.
Ours is a democracy that is inclusive, that is plural, that respects the views of the minorities, right? So the bar, the lawyers' body should be more vigilant and assert their independence. So the final word I would say is, without independent lawyers who believe in constitutional values, we cannot suddenly expect that we will have judges who embrace constitutional values and assert their independence.
True.
So
Very
this is
true.
something that I would want to share with all of you.
Definitely. Thank you so much, Justice Murlidhar. Talk to you again. Bye for now.
Thank you. Thank you. Bye bye.